welcome Hank and welcome everybody else. Thanks for making the time to join us on today's webinar. We're going to be discussing small business and the law with our very special guest, Mr. Hank Spier, who is ALNA's legal specialist. We've got a 30-minute webinar planned today, so we'll be hearing from Hank, who is an ex-ACCC CEO. He's a legal expert and small business advocate. So please submit any questions you might have using the Q&A button at the bottom, and we'll endeavour to answer those as possible later on. For those that don't know Hank already from one of his previous webinars, Hank is well known in the small business sector for his extensive experience in competition law and contributions to the Law Council SME Committee. His advice has greatly benefited groups like ourselves and other small businesses and other organisations in areas such as contract law, unfair contract terms, franchising, collective bargaining, disputes and misuse of market power as some examples. With Hank's assistance, we've certainly been more effective in representing our members over the years, especially when contributing to ACCC discussions on mergers and authorisations, and also in our submissions that we produce from time to time to different consultations on legal reforms and other consultations that impact our members. In addition to Hank's contributions at an organisational level, Hank offers preliminary advice to individual members of our association, navigating legal challenges, and is also available for direct consultation for an extra fee if required. We're delighted to have Hank with us today, and we appreciate him sharing his time and expertise. Previously, when we've had Hank with us, we've extensively discussed the frequent legal errors small business owners often make, particularly concerning their contracts. We'll be dedicating a portion of today's session again to this topic as a bit of a refresher. Following that, we'll address other concerns relevant to our members, such as unfair contract reforms, typical issues in franchising, and recurring queries about the boundary between misuse of market power and what's just tough contract negotiations. So welcome again, Hank, and welcome listeners. So my first question, Hank, is if you could maybe give us a bit of a brief overview of some of the key legal obligations that small business owners of news agencies and lottery agents need to be aware of and observe when operating.
Well, thanks for that, Ben, and good morning, news agents and lottery agents and any others who are looking in. Look, strange enough, the obligations on, say, news agents, which are basically small businesses, are not as great as they think, but there are certain obligations. You're a business, you deal with customers, and you're not to sort of mislead customers. You're not to sort of somehow dud them. Having said that, there is a lot of obligations on big business when they deal with you. And Ben mentioned what kind of advice I would give small businesses generally, particularly in relation to contracts. And there are contracts and contracts. There's a very small contract that you enter into with someone you've dealt with before and you trust. You probably trust them and you needn't be too suspicious or go too far. Then there's the more complicated contracts, particularly when you're talking, say, about franchises. And my view is, and I know it'll cost a little bit, it is always worth getting some advice from the local lawyer or even the accountant who can spot issues on contracts. I see contract after contract where people have entered into the contract, haven't thought about it, trusted the sales representative, and after a while, things go wrong. I had one recently, and some of you will say, oh yeah, the photocopier scam, where a news agent entered into a deal with someone for a commercial photocopying facilities. But at the same time, through the same salesman, entered into a separate deal for the finance. Now, in a way, those two deals are linked, but legally they weren't. Eventually, the photocopier deal fell over, but the finance deal is still there. So the newsagent is in this unfortunate position where the photocopier sort of service deal is gone, but they still have to pay the finance. Now, I would be prepared to challenge that in terms of unfair contract law, etc. But you don't want to get to that situation. You really want to have someone look at a contract or contracts before you actually sign up, and that's always my strong advice. And frankly, lawyers or accountants don't cost that much. They cost a bit, and you'll be scared, but they don't cost that much. And the law.
Just on that, I mean, you always recommend to me that members have a relationship, at least with a local lawyer as a client. Yep. And I know you've touched on accountants as well. And like, obviously, I think it's almost every one of our members would have a relationship with an accountant, yep. But they won't all have a relationship with a lawyer, or they may not have an immediate use for that local lawyer. Yep. In your experience, like, should they basically just, talk to some other businesses in their area, find a reasonable local lawyer that they're familiar with, and then, basically go and have a conversation with them and say, look, I don't have a particular piece of work for you, but I'd like to be a client and I'd like to have a relationship so that when I've got a contract or something I need you to have a look at, that I'm already a client. Is that the approach?
Yeah, I mean, I think that's good advice. The reason why I add accountants is because everyone's got an accountant. An accountant can probably spot something that isn't all that, something that looks a bit odd, and maybe refer them to a local lawyer. I suppose the point is someone else rather than the business person should look at a contract, even if it's, you're a trade association, because there are a lot of little traps, and I see them constantly, where people simply they've trusted someone, they've signed up, and there's a problem. And look, local lawyers, particularly in country towns or big regional cities, I'm sure you can come to some arrangement with a lawyer. And don't forget, lawyers negotiate their fees. So don't just initially be conned by, my fee is X. So, well, look, can we halve that, or can we do a deal?
Yeah. No, that's good advice. And I mean, obviously, we look at various contracts from time to time that members have raised concerns or have got questions about, particularly franchise agreements and that sort of thing. But it's not always the case that we can give legal advice per se, and sometimes there'll be other contracts, particularly leasing contracts and things like that, where a member will need to get their own separate advice. So with that, I think it's always good to have that relationship in place if they need that advice. But and in those other instances, they obviously can rely on ALNA to give them some suggestions around changes that might have been in the contract.
I mean, I agree with that, and particularly, you mentioned leasing contracts. They're one area where I think you need legal advice, because you're often talking about a fair bit of money.
A lot of money. Yep.
And you need legal advice, because they're invariably complex. They're invariably 50 pages or something. You just can't sign up and then later sort of, oh dear, this was all a bit of I signed up for something that I shouldn't have. Look, we all know that landlords are difficult anyway, so you need a bit of you need some protection.
Yeah, absolutely. And looking at some of the other things that impact members, I mean, ALNA, for instance, has done a lot of work to advocate for and successfully introduce unfair contract term protections. And I know you did a lot of work with us way back when on that. And we've made sure that members' contracts were covered by those protections as they relate to standard form contracts. Now, the Australian Federal Parliament late last year, at the end of a process of reviewing those laws, passed significant amendments to that regime, and ALNA argued as part of that process to increase the scope of the regime and applicable penalties. Now, those changes come into effect on the 9th of November this year, and I think it's an important change that members should be aware of. Can you tell us a bit about the new reforms the government has adopted and how they'll assist members?
Well, look, the new reforms are important. They took far too long to come into effect, and even the current government gave them a long period to sort of come into place. The new reforms don't change the basic law, but they do extend the jurisdiction as to which contracts are covered. They give the ACCC more power in terms of taking action against unfair contract terms. They tighten up as to what's a standard form contract, because there was some doubt about that. What they actually do, and when it comes to ALNA members, I think most ALNA members are covered by the existing law, and particularly the new law. It takes the unfair contract terms law a little bit further down the track, more protection for small business. And what I say, the unfair contracts term law, whenever it impacts on small business, is one of the most important changes to small business protection that's happened in many years. It gives you leverage, it gives you some power, and it gives you a power to look at contracts and maybe exercise, say certain terms are unfair, and have them changed, or any other action. They're very important, and I think people, again, when lawyers are looking at the contracts, they must be aware of these changes, and a lot of, have to say, some lawyers aren't.
No, they don't seem to be. I mean, certainly our lived experience has been that over the years since those protections came into place, we constantly come across contracts that haven't even considered them, which, you know, find extraordinary. I mean, most of our large suppliers certainly have made changes to their contracts, and obviously they'll need to review those again as we come through the reform process. But a lot of smaller contracts I come across, you know, even in recent times, haven't properly considered those reforms. And I think, you know, when they first came in, we obviously did some work to get an amendment to actually make sure that the thresholds for those protections were higher than they were first proposed. And I understand with these reforms, those thresholds will be increased again. Which hopefully will expose, you know, some of the bigger contracts that our members have to sign up to those protections.
And look, the other thing that happens from time to time is that a supplier, particularly an international supplier, simply dusts off their American or US contract and says here, but you know, they may not comply with Australian law, particularly when it comes to unfair contract terms. And unfair contract terms are issues like sort of automatic rollover, one-sided termination, and one of my bugbears is cost shifting. There's a whole lot of areas. And can I also say, whilst the ACCC and ASIC in the financial service area have jurisdiction to enforce the law, they're not going to enforce individual issues. That's just not, they don't have the resources, or that's not their role. They'll look at systemic issues or industry-wide issues, but not individual issues. But the law gives you leverage, and that's the important bit to get things changed. Once you get lawyers' advice or ALNA's advice, then you use the law as leverage to get things changed. Now, if you don't get things changed, and they're serious, maybe then you go to the ACCC, because ACCC does not have your commercial interests at heart. They have the wider community interests at heart. So you have to some extent, use the law yourself. And ALNA, we regularly do.
Absolutely. I mean, certainly we've got a track record, and no small part thanks to your advice over the years of getting those significant changes that have protected our members. So it'll be interesting to see when those changes come into effect in November, how that impacts the relationship between small businesses and large during that period of time. I might move on now to discuss, I guess, obligations of Australian small businesses under the Australian Consumer Law and Fair Trading Act, and how can businesses ensure they're not misleading or deceiving their customers, for example. I recently, just on a local sort of community Facebook page, noticed a lot of people talking about a local business here where they'd experienced when they had bought a product or were going to buy a product, and the product said it was $4.95 on the price tag. And there was a consistent issue where when they actually went to pay for the product and it was scanned at the point of sale, that it was coming up with a different price. And so there was a growing awareness in the community that this was happening with this particular fairly busy retail store. And then it kind of exploded on this sort of social media forum, and all these people were discussing it. It was quite fascinating. You know, an example like that, where obviously, you know, customers have been misled or deceived, and credit to the small business once they realised, they very quickly owned the issue and resolved the issue, and quite transparent about what had been going on. You know, what should our businesses be looking out for that they're not doing or shouldn't be doing, you know, to make sure that they're not deceiving their customers?
Well, obviously, I mean, it's not only a legal obligation, but it's a fairly obvious commercial obligation. Don't mislead your customers. And one of the tests is to often look at your promotions, or look at what's going on and see, well, am I misled by this? And it's often a fine line, but this example of the difference between the sort of the price on the shelf and the scanned issue, that's been a problem for years. And there used to be a code of conduct which still exists, but not all that. It's not all that sort of not all that well known these days. Where if there's a difference between the scanned and what's on the shelf, then the shelf price is the one that that is to be charged. Now, but it's simply misleading if there's two different prices, and obviously stores need to be very careful that there isn't a mistake, and the mistakes are easy made, particularly where you have a lot of items, like a grocery store. You know, you got tons of items, things go wrong, but you also shouldn't mislead customers for legal reasons, and that the customers can run off to fair trading or to ACCC, and you don't really want that. But there's the commercial issues. You don't want to chase your customer away. The other issue is, and this is not misleading conduct, but it's guarantees and warranties. I quite often have the issues come up where a consumer has bought something from usually or a small shop, it doesn't really matter, and it's faulty, and takes it back. And the retailer says, "Oh no, it's not my responsibilities, it's the manufacturer." Well, I have to say, you're both responsible by law, and you cannot simply say, "Oh look, send it off to the manufacturer," or "I'll send it off to the manufacturer," or import, or whatever. Or you are both responsible. So the best thing is to give the consumer their refund or a new item, and then you sort it out with the manufacturer stroke importer. And that's a common issue. And particularly, you know, and this is often not done deliberately. Staff are often protective of your business. And when someone says, "I want a refund," the initial reaction is, "No, I'm not going to give you a refund." But, you know, if the product's faulty or misdescribed, then you, the small business, as well as the manufacturer importer are liable.
Yep. So basically, it's the onus is on the small business to deal with the problem and then go and seek a remedy from the manufacturer after that, if that's the case. Is that correct?
Yeah, yeah.
Yep.
Now, look, some manufacturers are very good and they come up with a quick system if things go wrong. But a lot of manufacturers, and of course, we have a very high proportion of our stuff is imported, and importers are probably not as helpful as a lot of manufacturers are.
No, that's exactly right. So you want to have good relationships with good suppliers who are going to back you when push comes to shove with the customer relationship. And so, other than sort of refunds and pricing, getting pricing right, I know some of the other things that come up from time to time are things like, promotions where you're making a claim about it being, the best price available or the best offer in the market or the cheapest price. With things like that, how do members need to, how should they approach their sort of marketing claims?
Well, look, any claims made need to be able to be justified. However, there are claims and claims. It depends how specific the claims are. If you say, I'm the cheapest shop in say Gunnedah, right?
Yep.
It's probably so specific that you really you need to justify that. But if you just say I'm the cheapest, I'm the best, there's a thing called puffery. Puffery is basically self-evident nonsense. Everyone's the cheapest, everyone's a discount, everyone's on sale. And of course, over the years, I've always said, look, so no, you're not really misleading anyone because no one believes it, because it's just self-evident, well, crap, actually. But when you get very specific, then you really have to be able to justify. And look, everyone will come up with examples or so-and-so claims to be the best. But does anyone believe that? Because you have to, misleading conduct is someone misled?
Yeah.
And
that's a question of fact, I guess, and interpretation and their perception.
Yeah, but there's also the normal common sense in the world, and if people will sort of promote their product, and they will say they're the cheapest, but in most cases, no one believes it. But if you're very specific, like I'm the only shop in town that has a particular product, and that's wrong, well then, the more specific that you get, the more careful you have to be.
So I suppose that good piece of advice is when putting together your marketing promotions, don't be too specific. You be slightly more general in your approach.
Yeah, unless you're very confident. Unless you have done a deal with someone, you're the only person in town that has a particular product, and you know that,
by
all means promote that, but you have to be sure that it's right. Because I'll tell you what, you don't have the ACCC or Fed trading around near every shop, but there's a big police force out there, and it's called your competitor.
Yep. And your customers.
And your customer, particularly your competitor. But your customers may not know, but your competitor will.
Yeah. No, very true. I might move on now to data protection and privacy. Obviously, a lot of members will have seen a lot of issues in the media about protecting customers' data. And so I wanted to ask you the question about what are the legal obligations that, small business members like ours need to be aware of, particularly in light of those sort of focused issues in the media around the Australian Privacy Act?
Well, it's a bit of a mixed bag, and there's the legal, again, there's legal and there's commercial. You need to protect your customers' information, not just for legal reasons, but for commercial reasons too. Your customers need to trust you. Now, small business, I suspect, doesn't hold as much information as, say, the Medibanks of this world, or Latitude, or anything like that, but you do hold some. At the moment, the law is such that most small businesses are exempt from the Privacy Act. However, that's about to change, and small business will be covered by the Privacy Act. So the responsibilities that big business has will also go to small business, and they have to protect. And particularly, and this is where it gets a bit more difficult, if you're aware of a breach of privacy of someone's private information, you will have to report to the Privacy Commissioner within 24 hours. Now, often you won't even know.
No. But
within 24 hours, you have to, and in that report, you have to also say what you've done to protect it, what you've done this, so it starts to get a bit onerous.
Certainly does. And I know something I'm mindful of with our members, that we're going to have to provide more education around sort of, their cybersecurity risk and how they can manage that. And fortunately, there is a really well-funded new program that's going to be available through Council of Small Business Organisations fairly soon, called Cyber Wardens, which has been funded by the federal government. So hopefully we'll have more information on that for members in the not too distant future. So shifting focus again, maybe to franchising and license or agency agreements, could you discuss with us some of the recurring concerns and issues that members bring up with you, that relate to those types of agreements? Obviously, lots of our members have, franchise agreements with maybe lotteries or a marketing group, or they have license agreements with similar organisations. So is there something in particular that comes up a lot?
Well, yeah. And of course, there's franchises and franchises. Some are good, some are bad, and some have almost government backing and others don't. What comes up is often issues like termination, like my bugbear, cost shifting, where franchisor expects the franchisee to update the premises, update the signage at their cost. And another issue, of course, and it's very, very vexed, is if a new franchise is given to someone just down the road. And that's probably one of the most difficult and horrible issues. If you've paid a lot of money for a franchise and you think you're the only franchise in the area, and then suddenly your franchisor gives another franchise down the road, there's you won't like that, and you will probably see if anything can be done. I have to say, not much can be done, because the franchise agreements are seldom exclusive of any territory, and the franchisor simply says, "Well, okay, I can do this." I have to say, I was involved, or I handled on behalf of a ALNA member, an arbitration on such an issue under the Victorian law, which with this Victorian sort of lottery license, which is supposed to help the agent. It turned out it didn't help much, because it was all too difficult, and we thought that we wouldn't, no risk of having legal costs, and we ended up by having a risk of legal costs. So we withdrew, and are seeking some help from the Victorian government to tighten up a license. But that's one of the most common complaints, of course, is that the franchisor appoints other franchisees.
Yeah, it's a very vexed issue, and we obviously spend a lot of time with members working on those issues because it's quite an emotional issue too, naturally, because you're worried about the viability of your business and how it will be impacted. And you know, while some of the outcomes obviously, you know, there's not too much to worry about, sometimes there is, and so it is a particularly difficult issue for us to deal with. And you sort of talked about dispute resolution. You know, can you give any advice to our members who might find themselves in a legal dispute? Are there any sort of preventative measures that you can recommend to avoid such situations?
Well, going back to what I said earlier, make sure that you got some advice on the contract so that
Yep.
you don't get into the dispute in the first place. But if you get into a dispute situation, again, maybe talk to the local lawyer, talk to ALNA, or contact me. Try and resolve the dispute if you can, because disputes potentially take up a lot of time and effort, potentially cost. Your role is to run your business and not to spend time doing submissions or documents or something. But in many cases, in a dispute, there may have to be a compromise, and that's probably better than if a dispute drags on or if you lose totally. But now, I'd avoid, from recent experience, I'd avoid arbitration. See if you can have mediation. At least see if someone can sit in between the parties and say, well, look, surely this is fair or that's unfair. Can we resolve? Because in many cases, the other party to a dispute doesn't want to fight either.
No, that's exactly right. And look, there are some very low cost dispute resolution mediation mechanisms in some of the states through the small business commissioners, and they can be very useful. I did note recently, for instance, the Queensland model is much more expensive than some of the other jurisdictions when we were dealing with one recently. And we'll certainly be doing some work to try and address that to make sure that there's a sort of consistent approach across the different jurisdictions. But, you know, I guess the best thing is to try and mediate an outcome before you actually need to go down that path. And as you said, be prepared to compromise.
And look, there is another mechanism which I've used personally a fair bit, and I've used it on behalf of some newsagents around the place too. And that's going to ACCC or QCAT, NCAT, depending, those all in different jurisdictions, because they're low cost, and invariably those sort of things are settled. They don't go to hearing, they're settled.
Yeah.
And it's not that hard. You can do it yourself. I had one in QCAT that was settled extremely well for the member. Others, yeah, they've all gone okay. But no, it's a bit more than mediation, but it's a form of forced mediation, because what the ACCCs, QCATs, NCATs of the world do, as soon as there's a matter, they try to mediate it. Their aim initially is to get rid of it. They don't want it. They don't want your bloody problem, and they try to mediate it. So, but it forces mediation rather than sort of umming and ahhing, going on letter after letter after letter between the parties. They force mediation. And
okay, that's good advice. Now, I'm just cognizant of the time because we're a little bit over. I've sort of got one final question, but I've also got one question from the listeners, and I might kind of join those two together because they're sort of similar. I mean, members occasionally express uncertainties about the fairness and reasonableness of certain situations. And I was going to ask you, could you interpret the distinction between fair and tough bargaining in a contract? You know, what does good faith mean, and you know, how do we delineate between that and what might constitute a misuse of market power? And the members really asked about, you know, some terms get dictated to us by our, you know, through our supplier relationships, around, changing, for instance, from a percentage commission to maybe a fixed margin, or having processes that might impact our total remuneration. Are those things where unfair contract law would come in, or are they just, tough negotiations as part of the initial contract? If that makes sense?
It makes sense, but let me answer some of those things very quickly. The unfair contract law is unfair contract terms, right? And it doesn't apply to what's called the front up term, i.e. the price.
Yep.
It doesn't apply. That's exempt. I don't agree, particularly on where contracts are renewed and there's a loyalty and other non-issue, that front up exemption shouldn't exist, but it does. So, that doesn't exist. Can I just quickly, abuse of market power? Look, I know it's bandied around, and unfortunately, a lot of small business thought the changes that were back in 2017 would help them, and it didn't. Abuse of market power is useless. Let me just put it that way. The ACCC has taken a couple of cases effectively against statutory bodies because they've got particular power. The test is substantial lessening of competition in a market. It's not the test that you are hurt as a competitor. It's substantial lessening of competition in a market. So take the classic complaint. There's a IGA in a small town. Woolworths opens up Woolworths now, and that will hurt the IGA enormously, but it's not substantial lessening in a market. In fact, it probably is pro-competitive for the consumer. So abuse of market power doesn't help. The commission and the government is talking about unfair practices. They're not sure what it means, but it basically means conduct that isn't in the contract. So it's not unfair contract terms. It's not abuse of market power because it's probably pro-competitive, but where it's not particularly fair, and particularly withholding supply in certain areas, withholding spare parts in certain areas, generally action that's not commercially sensible at times, but is damaging.
Okay. And so really what you're sort of saying is that things like misuse of market power are fairly superficial protections, or very, very difficult to prove.
Yep.
Unfair contract terms, I mean, my experience is that things do often get challenged using UCT. Is that correct?
Oh,
so
yeah.
UCT has been fairly effective in that, under the current regime, an unfair contract term can be struck out of a contract.
Yep.
And my understanding is under the new regime, an unfair contract term will basically be illegal.
Yep. That's right.
So they have been quite effective. The other one that often gets talked about is good faith as it applies to franchising. Is that used much, or is it largely superficial, like misuse of market power?
Oh, it's not. Well, again, lack of faith doesn't substantially lessen competition in a market. So abuse of market power doesn't apply. It might be unconscionable conduct, or in some areas, like in franchise, it's part of the franchise contract. Good faith. Good faith is still somewhat vague, and it's often a case by case.
And is it similar to unfair practices? It's like the expectation to act in good faith is the same as an expectation to act fairly?
Yes. Yeah. It's act fairly, be upfront, don't hide things which you shouldn't. And to some extent, of course, hiding things that you shouldn't is also misleading conduct.
Right.
So some of these things, say, overlap.
Yes.
But good faith, again, it's the courts will look at it and say, well, what's fair in the circumstances? And particularly, and this comes back to also, if you haven't sought legal advice on some of these more complex contracts, and there's a allegation of lack of good faith, most courts may say, well, you should have got legal advice.
So once again, it comes back to having done your due diligence at the beginning and being able to prove that you've done your due diligence.
But for instance, I'll tell you a good faith issue is a franchising. If you buy a franchise and you later find that there's a franchise open up down the road. Now, if you can later find out that the franchisor already had that in plan to have another franchise nearby, well, that's obviously a lack of good faith.
Okay,
if they haven't told you.
Yeah. So if it was in a fairly short period after you'd taken on that franchise.
Yeah, or even short, but I mean, they may have had a long-term plan to have franchises here, and one of them happened to be next door to you.
Yep.
And they didn't have someone lined up yet, but they had a plan that they were going to open up a franchise. And you can't show growth in population or anything. There's no real basis. It's simply that they want as many franchises as possible.
Yep. Okay.
Or say lottery agents.
Very, very interesting. And so it'll be interesting to see if those unfair practices come in and how they sort of change the landscape. But it's been great as always to talk about these things.
Can I just say one thing on unfair practices? I think initially any unfair practices that will be covered by the government will relate to consumer issues, I suspect.
Yes.
So
okay.
Small business needs to really push to cover other issues. Now, some consumer issues and small business issues are the same thing, but in some cases they're not. And this is where a small business has to really push and say, no, we want to cover small business issues as well.
Yep. Thank you for that, and thank you for covering so many different areas, from sort of practical tips and how to handle contracts all the way through to some of those broader issues around fairness. I wanted to remind members about our Boost Your Business program. There is a module in there called Managing Legal Compliance and Business Obligations that Hank assisted us in developing, and that covers everything from employment obligations, work health and safety, ATO, ASIC, superannuation, tenancy and leasing, and a range of other legal compliance and business obligations. So that's always a really good one just to refresh yourself about your obligations that you need to be aware of in running your business. And thank you, Hank, for your assistance in putting that together. And apologies to people, we have run over time today, but it is a fairly broad issue, the issue of small business and the law. But it's been really helpful, Hank, again, discussing these issues with you. And I've certainly gained a lot of knowledge, as I always do when we have these chats. And we hope to have you back again for further in-depth discussions on these topics. And to everybody that's attended today, we really appreciate your time. Thank you. And we will have a recording of this webinar and also a Spotify audio podcast of this available for members if you want to have a listen again. So thank you again for your time today, Hank.
Well, thank you. And all the best to everyone.
Thank you. And thank you, listeners.
Boost your business. Take this 3-step online skills course to help you and your team beat daily challenges, increase profit, and add value. Developed by ALNA and industry partners. Join us to start using Boost Your Business for free.